So I hope everyone's having a good week. You guys want to go ahead and sign in and we'll get ready to start. Get my screen share ready while you guys are doing that. Screen should pop up there any second. So I've got the slide deck for week 6 course. So it's hard to believe we're already in week 6. This course is flying by. The 8-week semester is going quickly. So the slide deck should be visible on your side. Can everyone see it? If you just kind of give me a thumbs up. Sometimes I just assume that you can see it and I take it good. Okay, thank you. I appreciate that, Carrie. I just assume that it is, and I start off and I see hands start going up like, hey, wait a minute, where you at? So week 6, talking about looking at IEPs, list restricted environment, FAPE. We're going to talk a little bit about it, cover it in the content for week 6. This slide deck is in the course shell and available if you need to go back and review it or use it as a resource. Um, Talking about responsibilities of the IEP team. Most of you guys probably know this because you're in that role, but there are different specific responsibilities. So we look at the team member. So we have the parents, obviously, right? We want them involved. They have to give consent for testing and all that. We definitely want them involved. So that can be a biological parent, foster parent, guardian, whoever is acting in place of that parent. Could even be a grandparent. You probably see all kinds of situations out there due to circumstances those students are having to go through. Um, So responsibilities, we want parents to be actively participate in discussions. We want them to have an active role. We want them to partner with us and help implement some of the um, uh, things that have been put into that plan to reinforce what you're doing in the classroom. And we want them to be able to do some things at home in the evening to help out, support what you're doing. Next one is general ed teacher, and so this could be more than one. Sometimes you will see that representative from the LEA. Usually, that's you're going to be your special ed director, coordinator, or building level principal. Basically, they are the ones that make sure core academic instruction is being provided, that making sure the accommodations and modifications are implemented. LEA rep basically will supervise, make sure that program is being implemented, contributes to the understanding of general ed curriculum, and also presents information about what resources are available through the LEA. Oftentimes, especially your administrator is usually kind of the one person that may be there to answer any type of financial type decisions pertaining to resources outside of the district. So, what's available and what the district can and cannot do. And then you have educational professionals who often interpret evaluation results. That can be your school psychologist, your school psychometrist. They are an active member of the team, and oftentimes, especially when we're looking at initial placement, we rely on and need their recommendations on potential placement. They'll give you the what they feel like their professional recommendation is based on the results that they got, and they'll put that information out there for the team to consider. Okay, so that's something I have to do when I go in and do contracted testing services. I throw that out there just based on the statistical information that I collected through the assessment process. Okay, that's just one piece of the puzzle or the pie that we look at. Okay, the IEP itself, we know that it's a federally binding document, right? What's in that plan is something that has to be carried out. I mean, it's all in law. So it is a legal binding document. It's a contract between the district and the parent for providing services to meet that child's needs. It's a fluid document. Changes can be made as needed. Okay, you can do a review, go in and make any changes. Some of the things maybe that are put in there are not working. Okay. student may be struggling. We might need to change some of the goals on it, or the student is making tremendous process. We want to change some of those goals, maybe challenge them a little bit to enhance some future academic growth.
Can I ask a question on that?
Yeah.
Because I'm actually in a situation right now that we've had two different meetings. In this case, I was trying to dismiss the student. Um, so she has exceeded her goals. Like, and I mean, not even like I can't even find a goal to write for her. Like she has gone beyond. And
Okay.
so we had two different meetings with parents and we've presented the information and not just me, but all of her teachers. And then they were like, okay, can we? So her ELA teacher was not able to be there yesterday. So
Yeah.
they were like, she's had her for 2 years. Can you have her come in? So we had another meeting today. And I think mom was under the impression that the ELA teacher would disagree with me and be like, no, she really needs to stay on this IEP. And it's not just about dismissing, but it's about when parents challenge. My question and my frustration is I have two different kids that I keep very OCD data. Like I'm very that is one thing I will brag on myself. I am very much data
Okay.
driven.
Yep.
So I get that, we have to have data to get them into an IEP. We have to have data to test them. We have to keep data for all the progress. But why is it that parents get the last say? Because now I've got two kids that parents cannot cut the apron strings, even though it's supposed to be a team decision. At what point can the parents be overridden? Because it's like, I mean, I don't have to explain to you or anybody on the Zoom that across the state we are just overrun
Yeah.
with not enough teachers and too
Mhm.
many kids.
Yeah.
So I've got two kids that are taking up, I don't want to say space. I have 32 kids on my caseload, and I guarantee somebody probably has that as well. Like, I mean, it is what it is. But it's like they are taking up resources that could be used by other kids. And I have data to show that they have both like excelled with their goals, but parents are refusing to allow them to be dismissed.
So
So,
what I was going to ask you, I'm sorry, I'm not trying
Mhm.
to cut you off. I
No,
was
you're
just
good.
my main question is why would they not want them to be dismissed? I mean,
Well,
what is
one
the
is
reason?
because they're scared about losing their accommodations and then them failing. One of them's a straight A student with 1C, and it's because she didn't turn work in. That was the one I had today, the second thing today. The other is a behavior. And mom is like, they both want that protection of the IEP. And what I tried to explain to them both was they're not using the IEP resources. Like they're beyond that.
Yeah.
And so, like, neither one of them come into my room at all. One of them I saw for the first time today.
So do you
But
have like monitoring only? Is that what you got?
yeah, and mom, like the one mom today was like, she wants to do like, oh, I just went blank on what she was calling it because it wasn't something that I do, but it was something that essentially what I've done all year because a kid does not come into my room. She doesn't utilize her accommodations. Um, and yeah, I just saw the question about the 504s. The student today does not qualify for a 504. At this point, if we reassessed her, she wouldn't even qualify for an IEP. But it's the fact, and it comes down to not just dismissals, but accommodations and just when you're changing things, when you do have, and this is, like I said, this has just been this last week that I've encountered this because most of my parents trust, the data that I give them and what they're saying. But I guess my question is, at what point does the data override a parent's fear of letting go of certain things, whether it be accommodations or the fact of, and we did suggest a reevaluation. It's not due to her senior year, and mom goes, nope, we're not going to do it now. Because again, mom's a SPED teacher, so she kind of knows all the ins and outs. But again, this child no longer
So let me
qualifies.
ask you this, and I'm trying to think how to word it without.
and be blunt with me. I'm fine because I mean this is
So,
where
so is
I
it
need help.
from the parent stand? Because a lot of times I see this, okay, so I'm just gonna
Uh-huh.
say it.
Yeah.
When you get in a situation like this and the parent is just adamant, a lot of times from the parent standpoint, it is a money driven decision.
Hers is more of a
Do you
fear.
understand what
You
I'm
say
saying?
money.
Money driven because
Yeah.
they have found a way for that child to receive some type of a benefit through SSI, and they've worked a system to where they're getting paid money on that. And if they go off that IEP, they're going to lose, could be several $100s a month. So that's why
Yeah.
we got
I will
into
look into
this a
that.
couple years ago, and they were just having a conniption fit, and it came down to that. It finally came out, and
Hmm.
and I suspected that, and the team did, and that's why they were adamant because they were going to lose a lot of. It was a money decision for them, and
Okay,
so
I'll look into that because I think on the behavior one that could potentially, well, okay, I say that. I hesitate to think that, but it could be because I haven't looked deeper into it. The behavior one was because he got arrested last year, for a situation that happened at the school, and the parents pressed charges like outside of school. And so I explained to her, I said, an IEP is not going to protect him from that. Like we can't protect him from certain things. Like a behavior plan and IEP will protect him from getting expelled, but it doesn't protect him necessarily from getting ISS. It just puts things in place, you know, to help him along the way.
help them
Um,
along the way. The only really thing when you get into the discipline side to where it really somewhat handcuffs you a little bit. I say handcuff, but
yeah.
is when you're looking at the ED category. So when you get ready to do
Okay.
the manifestation and all that, and it's a student that has a category VD, then that obviously is going to be
Yeah. We're in a
well,
situation like that right now with
yeah.
another student,
And
and it is.
so on a student that has ED categorization, and when you're looking at discipline, you are really limited on
Yeah.
that
And
compared
he
to another category.
Right. And he is not ED. Like I took him off a behavior plan because it's like I told mom just wanted that one more year of no situations or whatever for him retaliating. The one today was she literally had one reading goal. It was a words correct per minute. She is, and again, I brought everything to the table. It was just, and I can talk to you about it later because I don't want to
Yeah,
take
yeah,
up.
we can
Um,
talk a bit.
I just that it was even my principal was like, okay, we need to get our district person involved because we just didn't know how to do it. So yeah, if you have a few minutes, because I
Sure.
needed to talk to you after class anyway
Yeah.
for
Okay.
other things.
Yeah,
So
that's all right.
okay, all right, let's go.
We'll talk about. Okay, so the next
I've had
thing,
I've had the exact same thing happen. Yep. And I had to just, pardon my language, create a BS goal and put the kid on console because the
yeah,
parent, they want that safety net. And
Yeah,
it's,
and
yeah,
that's kind of where I'm
they
at.
just
You know, I
really
just
couldn't have
I'm very
taken that
stubborn.
a lot
resources that
of, like
student, but
Sarah said, you do a
you put them on
consult or a
console,
monitoring only, and just go on. But the thing
increase your
is, with the
increase your
common,
correct words per minute goal.
yeah, with accommodations and all that, those can be made by a regular ed teacher without them being on an IEP. I mean,
Right.
that is something that's hard to get
Yes, and
teachers
we
and everybody
presented
to
that to her.
understand,
Like
huh?
we had a whole, yeah, we presented that to her. We had a
Yeah,
whole plan B.
Yep,
Like,
you
we,
literally sound exactly like a meeting that I had last
yeah,
year. And
yeah,
I had to involve the director, and yeah, they parent refused. Luckily they
yeah,
graduated the next year, so
yeah. So yeah,
yeah.
and I told her I was like, if that's what it takes, then that's what we'll do. But like, I just in the future, because we've been carrying of this with three different students this year, and so again, I can talk to you after class about
Yeah,
it. But
there's
yeah,
no problem.
it's yeah,
Okay, next thing is looking at confidentiality. All that information, you guys, most of you know this because you're already in that role. It has to be kept confidential, IEP locked up. And then we're looking at FERPA, confidentiality for all students. Okay, we have to ensure that students have access to their or parents have access to their children's records. When would that change? When would that change when they don't? Anybody have any idea on that? You want to take a guess? Well, when they reach a certain age, right? When they reach a certain age, even though they're still in school, that student has a right. We actually had that happen in the district I'm at. The student came in, and there are forms that we have, and they specifically put on there they did not want their parent having access to that. Okay, the student was 18. In high school, there was some rift there going on, and that student didn't want their parents having access to it. Okay. All right, so that's something to think about. Some main causes of litigation and grievances. All right, FAPE, usually what is being litigated. Free and appropriate public education. Compliance issues is another one. State mandates what must be in an IEP, how those services are handled. Least restrictive environment. That's always the goal, right? To place them in the least restrictive environment. Okay, it's one of the most important decisions. And also when we're looking at the amount of time they're going to be served, what services they're going to have. Um, then processes surrounding IEPs. We know we have annual review, services provided, breach confidentiality, and methodology. Now, going back to Jody jumping back up, I'll just tell you at the end of the day, you get into due process and all that, and there's conflict, and you get into due process with those difficult parents. 99 times out of 100, those parents are going to come out ahead on the deal. I always say that every semester. It's just the way it is.
And that's why I tend to just, it's like you said, Sarah, like I'll do the kind of fluff
Do the
goal just to appease
consulting,
them.
monitor only, go on,
Yeah.
and and if they're junior, senior in high school, just know you've got a couple more years and just get them on out. But if push comes to shove and you go into due process, I'm just telling you, 99 times out of 100, that parent's going to come out on top on that deal. So I know that's hard pill to swallow sometimes, but it's just a fact and a reality how that happens. Freedom of faith. Okay, so it means special education related services that are provided at public expense under public supervision and without charge. Okay. Special ed, the numbers are growing. We have a hard time finding teachers. Jody mentioned that it's a common problem everywhere. Every state, every district, we're all faced with it, right? We're seeing more and more need. Obviously, it's costing more and more dollars to educate those students. Okay, and everybody's SPED numbers are going up. Okay. Also, it has to meet standards of the state education agency in which the state you reside in, including IDEA requirements, appropriate for preschool, elementary, secondary education in that state, and are provided in conformity with IDEA federal requirements. IEP must meet FAPE, no cost to the parent, right? Must be appropriate in light of the child's circumstances. Local education, LEA, or the state are responsible for providing free and appropriate public education. And also appropriate public education when a student needs to attend a private school for it. So I don't know if you guys are like in Kansas, if you have any funding set aside in Oklahoma. We have what's called the Lindsay Nicole Henry Scholarship. And so if a parent feels like that their district can't provide that service, but a neighboring private school can, they can apply for those funds, get them, and use that toward that tuition at that private school. It's called the Lindsay Nicole Memorial Scholarship Fund. I don't know if your state has anything similar to that, but we do here in Oklahoma. So are those funds widely used? No, not as much as you would think, but they are out there and available. Okay, here's the one thing you might remember. So, if parents choose to place their children in a private school and FAPE was available in the public school, the children may lose the right to receive FAPE. Okay. Something I just got involved in contracting testing services. Parents remove their child from a public school in a surrounding neighboring district here and put them in a private school. So, That private school doesn't provide any special education type services. They do some one-on-one and smaller class sizes and do some interventions. They don't technically have special education teacher. They don't provide any type of testing service. So the parents contracted me out to test, to do IQ testing, so the student could continue receiving um, services providing through their insurance. They needed an updated current IQ test. Okay. They couldn't get it in the private school. They had to contract it out, hire me to do it. Okay. So that's what you get into when you go from a public setting to a private. They may not offer those specific services. Some do. Okay, moving on, looking at a couple cases, really kind of what we're going to get into. There's two cases that we're focusing on this week. You're going to be asked to provide a summarization of the two, a short paper on that, getting kind of away from comparison maps and things like that we've been doing. This is going to be kind of a short paper where you're basically going to kind of summarize some similarities and differences between the two. So we're looking at what we call the Raleigh standard. Looking back in 1982, it was a case that was popular. It's all dealing with FAPE, provision of free and appropriate public education. Okay, and it was first addressed by the Supreme Court in 1982, where the court reviewed a case dealing with the Board of Education of Hendrick Hudson Central School District versus Raleigh, set forth how FAPE is determined by the courts and what has been determined the Raleigh standard. Was the IEP developed in adequate compliance with IDA procedures is one thing they looked at. And was the IEP reasonably calculated to enable the student to receive some educational benefit? Okay, so facts of the case. Furnace Wood School refused to provide deaf student Amy Raleigh with a sign language interpreter. Amy's parents sued the school for violation of the Education of All Handicapped Children Act of 75. That act requires that schools who accept federal funds to provide FAPE to all handicapped students. District Court ruled in Raleigh's favor. They agreed that Raleigh was not achieving her full potential because she was not able to understand as much as she would have with a sign language interpreter. Okay, so that was kind of the gist and the basis of that case and what the ruling was. Okay, 2000, looking at Andrew. So we had the Raleigh case going back in 82, and then Andrew, which is the second case, 2017. So student basically was diagnosed with autism and ADHD from preschool through fourth grade. They attended public school in the Douglas County School District in Colorado. Okay. So beginning in second grade, Drew engaged in behaviors in school that interfered more and more with learning. School district developed what they felt like were appropriate goals for the student in his IEP, but guess what? He was making little to no progress. The school district repeated the same goals from year to year. Okay, they weren't really changing the IEP up. They weren't going back and reviewing data and looking and monitoring progress. They just kind of used the same format, same goals, and just year to year. Well, guess what? Basically, as the student got older, the student regressed. They weren't making progress, right, with the same goals. So before he began his fifth grade, the parents withdrew him from school and enrolled him in a private school. Private school developed a behavior intervention plan that addressed specific strengths and needs. And all of a sudden, boom, the light came on. Students started making significant academic progress quickly. That's not good, right? Stagnant. He regressed in public setting because they didn't change IEP goals. They just kind of progressed forward, did the same old, same old. No, nothing to challenge. Change schools, go to a private setting, put a behavior plan, change some interventions, and all of a sudden students start to flourish. Drew's parents filed a complaint with the school district seeking reimbursement for their tuition payments to the private school. Okay. They're going back now, blaming the public school. They're wanting to get money to help pay for that tuition. Okay. Case basically began discussion on merely more than de minimis, which benefit is not enough. So in Andrew F., the court discussed prior decision in Raleigh and pointed out that Raleigh case expressly declined to adopt a test for determining substantive, tongue-tied, adequacy of the educational benefit. The Andrew F. decision also held that a student's IEP must aim to enable the student to make progress. So I'll just stop there and say this. Make sure that you're not using the same goals year after year, right? This right here is a classic case of do not do that. Supreme Court emphasized unique needs of each child and stated that progress contemplated by the IEP must be appropriate and in light of the child's circumstances. Further, the IEP turns on the unique circumstances of the child for who it was created, and every child should have a chance to meet challenging objectives. We want to put something in that's going to challenge them and force them to grow, right? We want to see growth. We want them to be challenged. We want them to grow and excel to the best of their ability, regardless of the severity of their disability. Okay? No matter what their disability is, we want to have goals in place that's going to challenge growth. Okay? Also, the Supreme Court recognized that any review of an IEP must consider whether the IEP is reasonably calculated to ensure progress, not whether it would be considered ideal. Okay, so we want to make sure in those IEPs that we're putting objectives, goals in there, SMART goals. Okay, bound by time. Okay, shows a significant amount of time. We implement the goal, we'll come back and review it, determine whether we're making adequate progress. So basically, to comply with the FAPE standard articulated in the Andrew F., IEP team must develop, monitor, and revise IEPs as necessary to ensure they are appropriately individualized and ambitious for the student. You may have an IEP meeting at the beginning of the year and the student is just making great progress. So we might want to come back at midterm and review it and change up some goals to challenge them a little bit. Okay, don't just keep doing the same thing. IEP teams must carefully consider each child's present levels of achievement, their overall functional performance, look at their disability and their potential growth, and review it, revisit it if necessary. Okay. Keep that in mind on this court case. Don't just keep doing the same thing year in and year out. Revise it as needed to make sure they are receiving appropriate services and make sure it's individualized and consistent with that child and their need. Okay, so here on the slide, it gives you some information. It's going to be a great resource, kind of help you. Here it shows you the Andrew standard and it compares it to the Raleigh on this slide, looking at 82 compared to 2017 and how the courts ruled on it. So we had one side, child had a hearing disability, weren't getting an interpreter in the classroom. Parents sued, came out ahead on that. Andrew, child had autism, ADHD. Basically, the child was removed from public to private school. Reasonably calculated in light of the child's circumstances, challenge of goals, and there was no what we consider bright line that must be more than de minimis. Okay, so basically they weren't changing the goals; they were using the same thing. Really, it sounds like they weren't even making an effort. Okay, we'll talk about least restrictive environment. Always remember this, keep this in mind when looking at placement and coming up with the percentage of time they're going to be served in a resource room versus regular ed. Least restrictive requirement. Okay, students must with disabilities need to receive their education alongside their peers without disabilities to the maximum extent that is appropriate. Again, it's going to be individualized. Students should not be removed from general ed classroom unless learning cannot be achieved, even with the use of some type of supplementary aid. The term environment in least restrictive environment can be interpreted to imply that LRE is a place or a location. Okay. It does not merely refer to a particular setting. Okay, so that there's more to just a single setting that we need to keep in mind on that. Okay, so rather identifying the least restrictive environment involves making program decisions about what services and support the student needs to be successful and how those services and supports can be provided effectively. Okay, so that's really the name of the game when we're looking at least restrictive environment. Continuum of placement services. Okay. IDA requires that school districts create a continuum of alternative placement options. They could range from least restrictive setting, general ed classroom, to the most restrictive to where they're in a residential facility. Students should not be removed from general ed classes unless learning cannot be achieved with those supplementary aids. So you can kind of see a little visual there showing the general ed classroom as being the least restrictive to the far left. Then we kind of go up in restriction to a special ed classroom, a special school, homebound, all the way up to residential, which is the most restrictive. Okay. And you may have some students right now, due to circumstances, they're in a residential facility. Okay. It's not uncommon right now that we're seeing that for mental health circumstances where they're being hospitalized. Okay. And they may be some of your students in our IEP. Okay, so here's in this slide deck, it's talking about the Rachel H4 factor, just kind of a summary of that. So, and it's a court case. Redondo Beach Unified School District, just kind of give you a summary of it. Spent 75% DR, the student did, spent 75% of the school day in a regular ed classroom. School proposed to reduce that time in the regular classroom to 44%. So for DR, his fifth grade year, DR's parents ended the IEP meeting, withdrew DR from the district, hired a private tutor for one-on-one home instruction, and then his parents filed due process seeking a decision that the district had denied DR FAPE in the least restrictive environment, and they sought reimbursement for their expenses. Okay, so the court found that the district had provided FAPE, but key term, they did not offer DR an appropriate education in the least restrictive environment. Okay. So determine whether the district had complied with IDE requirements, the students be educated in the least restrictive environment. Court considered factors it had established in 1994 in a previous case. Factors are academic benefit received in regular ed versus the more restrictive. The second area, non-academic benefits of the least restrictive environment. Third one, students negatively affects the education of peers in least restrictive. And also the expenses, services, and supports necessary to keep the student in the least restrictive environment. So the court acknowledged that the first factor was the most important, the academic benefit received in the regular classroom versus the more restrictive. Okay. Now, again, talked about we kind of getting away from some of the visuals on that, although if you choose to do that, that's fine. Make sure you cover. You can do the concept map, but also include a smaller reflection, or you can just do a full-blown summarization reflection. Either way, whatever you meet or choose method to do it is acceptable on this. You can do a concept map, a Venn diagram if you want to show the similarities and differences between the two. Make sure in that you do the following on that if you choose to do the Venn diagram or the comparison map. Okay. Make sure that you provide an explanation of the two laws, a description of how each law influenced special ed services. Okay. So that one slide kind of laid both of them out. You had one that focused on the sign language interpretation, and the other focused on another area. So make sure that you give a description of how each one of those court cases laws influence special ed services. Show a depiction, kind of the chronological order of each court case. Okay, so you remember one was there was 20 plus years between the two. If you look at them, okay. Give a description in your own words of how each law changed education based on the facts. And again, use that slide deck as a resource. Everything's pretty much condensed into that for you. And then just provide your reflection on the impact of both laws on education and special education. So basically, it's just your personal reflection, how you interpret that, of how both laws impacted that. There's really that part of it, guys. There's no right or wrong on that. Just give me your thoughts on it about how those laws impacted. Okay. Again, if you feel more comfortable on this and you want to do it more as a summary, a narrative, and get away from the Venn diagram and all that, you can. Or you can choose to do the Venn diagram. Just make sure you cover those areas right there effectively. Okay. Either way is acceptable. Okay. Any questions on that? Again, remember, we're just focusing on those two, Andrew and Raleigh, okay, and how the laws were interpreted and how the courts ruled. And then to kind of end it and wrap it up, your reflection on how both of those cases and the law impacted education in general and specifically special education. The main goal is, and you heard me mention this, always remember, keep in mind, least restrictive environment when you're doing this and looking at services, whether it's the amount of services in general education room versus the amount of services in the resource room or pull out. Okay. We want to make sure we maximize and focus on least restrictive environment. The second key point is not necessarily pertaining to what we talked about tonight, but going back to the comment, when you're dealing with difficult parents, guys, remember, and you're thinking, hey, we could really butt heads and this could go a ways down a pathway here. Just know if you're looking at due process and it gets to that point, just know at the end of the day, 99 times out of 100, the parent's gonna come out on top. Okay, I know that's hard to accept and remember and realize, but that's pretty much what happens. Any other questions, comments?
I saw on the syllabus that you were going to open the group work up.
Yes, I will open that up to where you can go in. So that's looking ahead. Thank you for bringing that up. Almost forgot. So you'll see in the syllabus, it talks about group scenario. Okay, and opening that up so you can sign up. So after class tonight, I'll get in there and open that up to where you can go in and sign up. So it will be something. The group scenario project is kind of this is week 6. That's one of your last projects, and so you'll like self-enroll into a group basically, and then we'll have scenarios, and your group will go in there and collaboratively come up with the best response based on the scenario that's provided. And they'll give you multiple scenarios, and you guys will work on that and complete that as a group and collaborate together. So I will open that up after class this evening, and then I'll post an announcement and let you know that it's there and available. Okay, does that answer your question?
Yes, thank you.
Oh, you're welcome. Thanks for the reminder. I almost forgot. Okay. Anything else? Everyone good? All right. Hey, as I mentioned, this is week 6, so we have the week 8, so it's going fast. It's being quick. All right. Of course, it'll be over before you know it. All right. If there's not any other questions, or if you have a question after you start working on this assignment, just please feel free to email. And if I don't hear from you, I'll plan on seeing you next Wednesday night. Okay, for week 7. I'm gonna do a stop share screen.
Are you still good to meet me for a few
Yeah, I
minutes?
am. I'm gonna stop the record and
Okay, perfect.
okay. All right. Thank you guys. Have a good week.